Welcome to the Stephanie Young Law Podcast, hosted by me, Stephanie Young. I'm a family law litigation attorney in Covington, Georgia, with a passion for being my client's biggest legal ally. Today, we're going to talk about the difference between uncontested and contested divorces. These are two main categories of divorce. In this episode, we're going to discuss the difference between these two categories, but we're also going to discuss the different legal role that counsel can play in these types of cases. So, when you call my office, and generally when you call most family law offices to inquire about representation for a divorce, they're going to ask you pretty quickly, they're going to ask you one question. Is this divorce contested or uncontested? Why do they ask that? Well, the main reason that us law firms are asking this question is because there's a big financial difference between uncontested and contested divorces. The other aspect is the time involved in the case. So basically, the firm's next step for you in that intake at that initial call is going to be dependent on whether it's contested or uncontested. So basically what I'm saying is they're going to have this expectation when you call to inquire about a divorce that you know the difference between those two things. And a lot of people don't. And that's okay. And that's why I'm really glad that you're tuning in this week and listening to this podcast. So what I'm going to tell you is that when it comes to an uncontested versus a contested divorce, if you're calling the initial call, so that's just you're talking to a paralegal, an intake coordinator, we're just getting some information. I've talked about this in previous episodes, but we're mainly trying to make sure that there's no conflict there. So making sure, getting your name and the name of your spouse so that makes sure that on our end, we haven't already represented your spouse or consulted with them before. So we don't waste your time and money. So the other aspect is what we're looking at is, do you need a consultation or not? A consultation in my firm looks like an hour of dedicated time in which we sit down in my office in Covington, Georgia. I prefer in person. We also have accommodations for virtual meetings via Zoom or via phone to really have a one-on-one meeting to discuss your specific case and giving you tailored legal advice for your situation. Now, uncontested divorces do not always require that consultation. The reason is because an uncontested divorce is a divorce in which you and your spouse are both on the same exact page regarding custody, visitation, division of assets, division of debts, etc., etc. And what I mean by the same exact page, I literally mean the same exact page. So if you call my office and you're saying, well, we both agree that, we want a divorce. Okay. That's good. That's helpful because not everybody is on that same page. But that doesn't necessarily mean it's uncontested. Or, if you call and you say, yeah, we talk. Well, no. And that's good. But uncontested literally means that you are on the same exact page regarding custody, visitation, division of assets, and debts. So let's talk about that a little bit more. What does that mean if you are going into a divorce and it is uncontested? I could do examples all day long, but if you agree on parenting time, does that mean it's uncontested? Not necessarily. Because if you agree on parenting time, but you don't agree on custody, so you don't agree on who makes final decisions on those big categories like education, non-emergency medical, religious decisions, extracurricular activities, then that does not mean that you're at the uncontested stage of divorce. If you call and you say, well, we both want to mediate. Well, that's great because it means that you're coming in with this open mind, that you want to try to work through your issues. That's great. But that does not mean that your divorce is uncontested because that means that you're not there yet. Okay. What if you call me and you say, well, both parties, we want to just hire the same attorney and then talk through things. We don't want to litigate. So when I say litigate, what I mean is we don't want to go to the courtroom. We don't want to go in front of a judge because not all cases require that. Great. But what I'll tell you is that you can't do that. So, and maybe other attorneys, other attorneys, I've seen them get this wrong. I've seen them say that, yeah, you can both hire me. No, you can't. Okay. Does an uncontested divorce absolutely really only need one attorney? Absolutely. Most of the uncontested divorces that I handle, I am the only attorney of record on that case. But it only takes one attorney needed to draft the paperwork. But as attorneys, we have ethical obligations. We are under the Georgia State Bar of Georgia ethical guidelines in which we can say we can only represent one party. We cannot represent the interests of two parties. So on we call the different sides of the V in the court case. So Jane versus Joe, right? If we use that example, I cannot represent Jane and Joe, just one side of that V of the parties. And so what that means is you only need one attorney to draft the paperwork, but that attorney can only have the best interest of one client, which is one party. So what this means is that if you and your spouse are completely in agreement on everything that we talked about, the custody, division of assets, division of debts, the visitation, the child support, all of those things, that's fantastic, right? But you're calling to say, we want to find an attorney. And it's frequent for both parties to be kind of even on the same phone line. But then what I say is, well, I'll give you a quote for an uncontested divorce. But you keep in mind when you're signing a retainer agreement, only one party is who I represent, the plaintiff. So whoever is going to be the plaintiff, y'all decide, that's going to be the party that I represent. That is an ethical duty. That is not something that can be waived. If you have an attorney that's waiving that, that is not appropriate. But that also doesn't mean that you have to spend double the money. If you're like, we're on the same page, Stephanie, we really are agreeing. We just want to make sure it's done right. First, I will applaud you for reaching out to counsel. Okay. Because and we're going to talk about that in a little bit in this episode as to why it's still so important to have counsel, even if you've got this full verbal agreement between you and your spouse as to the details of your divorce. But what's important to me is having an agreement. So during the divorce process, what we're going to have is a settlement agreement. If you have kids or not, you're still going to have a settlement agreement. The parenting plan, the child support worksheet, the child support addendum, those are all specific documents if you have children involved, minor children that are at issue of the divorce. But when we're talking about all divorces, regardless of whether or not there's minor children involved, you are going to have a settlement agreement if it is uncontested. So if you've reached an agreement. Now, in that settlement agreement, that is the most important document that outlines how you are going to divide all of your things. That's what you're going to reference when the final judgment and decree is signed, which that's the point that the judge signs that you are officially divorced. That's also the document in which you change your name. So if the woman is asking to get her name changed, restore it back to her maiden name, that document would contain that information, and you take that order to the Social Security office, the DMV. We can do an episode about changing your last name. If anyone's interested in that content, please comment down below. Let me know. I'm happy to, try to fit one of those episodes into the podcast because I know it's very relevant to my clients about what that looks like and whether or not that decision has to be made at the time of the final decree and all those sorts of things. And if you have questions related to that, go ahead and comment down below and I can try to incorporate them into that episode. But going back to the settlement agreement, that is your most important document along with that final judgment and decree that incorporates the settlement agreement and makes it an order of the court, because that's what you're going to be referring to as after the divorce is said and done as to, okay, this is what I need to do. It's almost your action plan of who gets what, who needs to do this, who needs to do that, and what obligations you have moving forward. That's the order of the court. Now, it's very important to make sure that that settlement agreement gets its integrity preserved. What do I mean by that? I mean, what you do not want to have happen is that you divorce your spouse. You get, let's say you do it on your own, okay? Uncontested, you use AI or whatever technology, online forms that are not attorneys, that have no specific knowledge of your situation, your judges, anything, and you use those, file those, get your decree. Okay, you might be officially divorced. But what if eventually one of your ex-spouse, they find an issue with the paperwork, or they come up with an issue and they consult with counsel? Because this has happened. I've had people come to me and consulting on old settlement agreements that say, yeah, the divorce is said and done, but this XYZ, this is why this agreement is null and void. Okay? That is a really unfortunate situation that you do not want to find yourself in. Because it doesn't mean that, oh, you're not going to be divorced, but it means that now a chapter that you thought was closed years ago is now reopening, and you depended financially on how things were agreed upon and divided in that agreement as far as making financial and life decisions that are now kind of, the box is opening back up, and there's a lot of, your peace is basically at risk, hugely at risk, because everything you've depended upon is now kind of has the potential to unravel if there's a finding made that agreement was null and void. That is very rare to occur when you've had counsel drafting the settlement agreement. So it's not to say there's definitely value in being able to have finality in orders. The court legislation supports this. So it is not easy to turn around, and I'm not going to sit here and tell you it's easy for the courts to turn around and overturn settlement agreements and find them void. That's not happening daily. That's not happening frequently. Me, myself, I've been practicing family law for almost a decade, and I can count on one hand how many actual settlement agreements have been found null and void in terms of cases that I have come in and either been the party that has, worked to try to find aspects of that agreement void, or helped people defend against those aspects. Not frequent, but still they happen. And when they happen, it's generally because pro se, which is what we call when parties are unrepresented. So if parties are doing their own forms in an uncontested divorce, well, then what that looks like is those are the situations in which people are coming back and realizing that they're going to have issues because now the agreement's void for many different reasons. One of the most frequent reasons is going back to what we discussed earlier, that maybe maybe one party had representation and there was absolutely no time. So if there was, let's just give an example. Your spouse hires an attorney. That attorney calls you and says, okay, you have 12 hours to come to my office, review, and sign this entire agreement, or it's going to blow up and we're going to, they can threaten, we're going to litigate and we're going to take all your money and we're going to do this or that. Then that party feels like they're under pressure. You could almost say duress, and they're saying, oh my goodness. And, and they rush there. They feel like they don't really understand it, but they don't feel like they have any time to consult with anybody else or any independent counsel, and they just sign it. Okay. That's not what the law wants to support of people going into these huge life decisions with just that rash, quick, harsh, decision making, right? That's not what the law supports, and that's not what we should encourage. And so we don't. And so when I say that I only represent one party, that's not just to protect myself ethically with the bar, which is very important, but it's also to protect you, because I always give the other party an opportunity to consult with independent counsel before signing the paperwork. So what that means is I'll say, hey, let's give 10, 12 days for you to be able to, before, as actually filing as this as a contested divorce, because there's also value in not just lingering, right? There's value in not saying, okay, we've got these drafts, but we're just going to leave it as uncontested for the foreseeable future. Well, no, you want to put a timeline cap on yourself. So emotionally, I talk about this a lot in my episodes, but if you've watched those previous episodes, you know me, and my style as an attorney is protecting your peace and really understanding that there's a huge emotional aspect that goes into play in family law. It is not just the Georgia Code. It is not just, the procedures. It's not just the legal arguments that we can make. Although very important, I believe it's quite a big ignorance to not also consider the emotional aspects of the client, which is you. And so with that said, there's definitely, I put a cap on there generally of 10 to 12 days to say, to review this with counsel. And you could say, Stephanie, why are you doing that? Are you trying to blow up the agreement? Or, are you advocating for me or my ex, or soon to be ex? And I say, well, no, I'm advocating for you by doing that, because by giving that opportunity, it makes it so once we do get that signature, on that agreement, it makes the agreement less likely to later on be void, which then, like I just discussed, you can only imagine what upheaval to your peace that would cause if years later, what you think is final, a finality, is behind you in your life, is now all of a sudden potentially not. That there's huge issues with that. So the next aspect that I'm going to talk to you about is the role of counsel. So if you're watching this podcast today and you're saying, well, I'm going to watch this because it's going to teach me of how I can do this uncontested divorce. No, you're not going to get that from me. And it's not just because, well, of course, the attorney's not going to say that, right? If you've listened to my podcast before, you know that I'm giving you genuine advice, not just advice that financially benefits me. It's genuine advice for you as a human being that I genuinely do care about, is that having an attorney draft even uncontested documents is so important. Obviously, the main things is that what we just talked about is to make sure the agreement's not void later on. But there's also issues that even if that agreement, maybe it's not found to be void, but you're still having issues. Like, for example, what if when drafting those, AI didn't realize, well, we didn't put in there what the pickup time for the children, the custody exchange time is when school is not in session. We only did it like, well, pickups from school or from the school bus stop. What happens if it's during a break or if school's canceled? What time do we pick up and where do we pick up? That's a big issue that, you guys could agree, but what happens when you don't agree? Because that's the whole point of the orders, right? To hopefully, it's great in a world where you don't have to look at it and you guys can co-parent and correspond, but they're made for the times in which conflict exists so that way it shuts it down. We have it. Okay, if we can't agree, the final decision maker is what this paperwork says. This is our plan. And so a lot of the times what I've seen very frequently is in which those agreements that are cookie cutter, right? They are not going to include those finesse details that are very important to your family. What if, for example, you forgot to discuss the division of a bank account? Let's say your bank account has $2,500 in it, the joint bank account. It said close it. Well, what happens with the money in it? And one party just thinks, well, I'm just going to take all that money, right? Or maybe the account has $100,000 in it and it doesn't discuss what do we do with the remaining funds. Those are the nuanced details that even if you're an uncontested divorce where you're like, well, we're going to agree, we'll talk about it. Even then, there's little small aspects that counsel can say, well, y'all also need to agree on this. And we deal with that while the issue's still fresh, while there's still an easy ability to add that into the paperwork before making it a final. It's still there. If you've got counsel that has done this countless times over a decade, I've been doing this and looking at these orders and seeing some of these orders from people that did it pro se or had different counsel have these issues. You learn by trial and error in terms of what works, what doesn't work. And, I've got 10 years of dedication to be able of examples that I can share as far as what those nuances look like. Something that forms online cannot do for you. Now, going back to, well, can you just redo this for me then? That's also very rarely an option. Settlement agreements they're not modifiable. So when we talk about modification matters. We're talking about very, very details. We're talking about everything related to your minor children. We can modify custody. We can modify visitation. We can modify child support. Those are what we typically modify. And the reason is because, and it makes a lot of sense, right? What is in the best interest of your children at 2 years old very well probably won't be what's in your children's best interest at 14 years old. And the law is very, very aware of that. And that's why you see modifications based on the children, because children are not fixed objects, right? You know, a house, what happens with a house and equity in a house, bank accounts, debts, those are fixed issues that we can talk about now, and they're finest, they stay the same. You know, between now and 10 years, you know, it's not going to change like children, and what's best for children is going to change. And so it makes a lot of, it makes a lot of just sense in general as to why those are modifiable and settlement agreements and division of assets and debts aren't. Now, like I said, there are very specific instances in which you can modify, but it's basically you're having to make a finding that the settlement agreement is void and we're having to redo it. It's not to say, well, we're going to just change this, modify this little aspect that we don't like you can in a parenting plan. So let's say that you've got these self-help online forms, okay? Because they're out there. Of course they are. The courts offer them in terms of, I know, like, you know, bigger courts like DeKalb County, Fulton County here in Georgia, you know, they've got forms online of a lot of different things because they see so many pro se parties, and, you know, the court can't give legal advice, so they just give those documents online, and it helps move their court system through a little bit quicker. They're out there. Of course, I'm not ignorant to the fact that they're out there. But let's say you get those forms, you sit down with your spouse, you know, you fill them out. Then what, right? Then those are kind of the nuances that you don't think about. Then how do you file them? You have to file them. What if they get rejected? Because, oh my goodness, there's so many different reasons. Even as counsel, you know, we get things rejected for various reasons. The clerk rejects them, and the clerk can't give you it's under Georgia code, cannot give you legal advice at all. So you can't say, well, what do I need to do to fix this, clerk? We can't help you. You need to get counsel or figure it out, right? They're not doing that to be mean. They're following the Georgia law. They cannot give you legal advice. So, you know, then it becomes an issue. And then let's say you jump through the hoops, like you fill out the paperwork, figure out how to file it. It doesn't get rejected by the clerk. But then what? Then what happens? Because that doesn't mean you're divorced, right? Well, what if you get a court notice? But what if I could tell you that maybe you could have even avoided going to court altogether if you had legal representation in your uncontested divorce? Advocacy occurs way beyond just a courtroom. That, if I could put like that on a t-shirt, advocacy is beyond just a courtroom. That would be huge. As a litigation attorney, which it means that I go to court, 95% of my cases are litigated. I go to court at some point, or at least the threat of court is pending. They're actual pending cases that I have. My role as an advocate very frequently happens over email. And that does not downplay that. There's huge things that can be advocated on my client's behalf over a phone call, over email, and mediation, in in-person meetings, just huge things that can be done outside of courtroom that is still very much advocacy work. It's not to say that, oh, we can just have a form do it or Google can do it. A lot of a legal professional's job, a lot of a lawyer's job specifically, is to advocate for your client outside of the courtroom. The time in the courtroom doesn't show all the preparation work leading up to what occurred to be able to get to that time in the courtroom. And so there's a lot of value in that. And I tell that to my uncontested cases because, well, I don't need an advocate because we're not going to court. That is just not accurate. A good attorney advocates even in uncontested matters by ensuring that, we've talked about this, that the paperwork, that it's done correctly, that I'm sitting here and I'm predicting issues for you that you might not even realize, because guess what? Maybe and probably you've never been divorced before. Maybe and probably you've never co-parented with somebody before. Maybe you have never divided a business. Even if you've gotten divorced, you've never divided a business before. Or you've never had issues with the IRS as far as, debts that you weren't aware of before that maybe your spouse had, and you guys were married, and that's coming up after the fact to try to protect yourself against. There's so many things I could go on and on and on about the nuances in each individual case as to why there's value in having legal representation, even when you have an agreement with your spouse. Now, I also want to emphasize that contested on the onset. So when I'm talking about you're calling up my firm, doing intake, and you're saying, I'm ready to proceed on a divorce. And you're saying, well, we don't agree yet, but we don't hate each other. I think we could probably try to talk some stuff out. Like I said earlier, maybe you say, well, we want to mediate. That does not, and so what I'm going to do is I am going to categorize that as a contested divorce, because that's where you're at right now, okay? You are at the stage in which, things are not fully mapped out yet. That's okay. That's most cases. You're not alone. There's value in feeling validated, and I absolutely preach that. You are validated, and that most people are not at that stage. But that does not mean, just because when you start the case that it's labeled as contested, okay, that does not mean that the case has to be resolved in court. Does not mean that we have to ever go in front of a judge. It just means we're not ready to be fully resolved in everything yet. I do want to talk briefly about how child support interplays with uncontested divorces, because this is also something that I do frequently get calls on about, well, yeah, we do agree, but we agree on talking like what our incomes are. We agree that there should be, credit. I'll say that the other party's covering the medical insurance, deviations for parenting time, all those sorts of things. Maybe you don't know that as the name, right? But you're like, we want to give credit where credit's due. We want to follow the child support. We want to follow the child support worksheet. That's all I need to hear. As an attorney, we can go in, and that still means it's uncontested. We just go in and we say, okay, we'll do the worksheet for you, and show that to you guys and make sure that as long as you agree on who's supposed to pay and those incomes, and then once I do a worksheet for you, you're agreeing on that number, then it's still uncontested. Just want to because that's another value that I especially think now. If you haven't seen my previous episode, go tune in after you watch this one regarding the legislative changes on child support as of effective 2026 this year. Go ahead and watch that. But it's very important that you have skilled legal representation filling out your child support worksheets for you. And again, that's another value that even as an uncontested, having representation to do that child support worksheet, which is included in an uncontested divorce in my office, it is going to be very, very important, and not to do that as the self-help way. Because there's no forms online for child support worksheets. There's a child support calculator, but again, not user-friendly, very much nuanced of you needing to know what to plug in, and only counsel can do that. If you or someone you know are contemplating a divorce, you are at risk of disrupting your peace, contact my office. We can set you up with a consultation so we can discuss a plan for your particular circumstance. Peace is priceless and attainable. We've got this. If you find this content relevant and you want to hear more, I ask that you subscribe, share, and interact by liking and commenting down below. Hey guys, I just wanted to jump on and give a disclosure that watching my videos does not create an attorney-client relationship. Also, the information that's contained within the videos is for educational purposes only. Thank you so much for watching.